And we can look at this too briefly before we move on to the matter of the $9 million cars, 43 cars for the presidency. Clara, what do you say about, is this news really? When the alleged killers of the former, MP for the late, former MP for Ebuakwa North, Mr. J.B. Dankwa Edu, were discharged because the Attorney General went in and put in a nolle prosequi, people started, showing some really signs of anger. But this guy, we were told he has confessed, or he said he's done this. Why do you do all of that? We understand, well, there's been a rearrest, there's been improved charges or new charges. So should we really be concerned about some of these matters?
Should people are entitled to express their opinions on how these matters are titled? Yes. But should we be concerned? I think there wasn't enough sufficient information from what was given. The law allows the AG to enter a nolle prosequi. The AG complied with the law. As a lawyer, and even that's like I said, that is the law. She gave her reasons, although she also said, and I think they were legitimate, she said she wasn't going to put out all the details because of certain investigative issues. So at this stage, I would trust her judgment and just wait for things to unfold. She knows the case that she's building. I don't know what evidence what new evidence had propped up that she wants to use. So at this stage, I would give her the benefit of the doubt and then see how the things unfold.
Okay. Doc, some say this is a sign that the AG is not doing a good job because recently you took a matter to court in the Delta Force, matter, and you went and put in a withdrawal and they got discharged. And you have given suggestions that you may do things in a different way, even go back to that case. There's another matter that was also pending. And then you throw in that they should be discharged, then you go back to redo things. It suggests, some lack of proper preparation in doing these things.
Well, I think sometimes we have serious misunderstanding out there as to how due processes are supposed to be. I mean, when I saw the story that JB's killers freed,
yes,
I knew that they had not been freed as it is. But that's how it was put out there by the media. It's not just they being freed. They wanted to have a second look at what is at hand, conduct more investigations, and it's a process that is known to our law.
Right.
So if that process has been resorted to, we have to seek for clarifications and not just point to conclusions as if the AG was about just ending that case completely. And the other bit also, because you mentioned the Delta Force, was that it is not in every case that when the case is discontinued, that it amounts to the filing or entry of nolle prosequi in a criminal matter. There are several stages in the criminal prosecution system. At some point, you may have to file that nolle prosequi. There are processes you have to follow, under Act 30. But there are also instances whereby we, in practice, see police personnel even discontinue cases. When a witness comes and then later on it doesn't come again, my lord, the witness is unwilling to, or the complainant is not interested in the case will therefore want the accused person discharged. Once you are discharged, you can be rearrested and then brought back to court when there are evidence against you. It's when you are acquitted and discharged that you can't be rearrested and charged on the same offense for you to go and face another charge. Otherwise, you then put up a defense of Otrefua acquit. But yes, that is not the case. So the Attorney General, because she's a new person, she didn't start with the prosecution. The cases the charges against...
there will be state attorneys who did it, and who will be the same person who do it anyway.
Well, but you have a new head.
Okay.
So if my colleagues look at the case and they think that there's a need for introspection for us to have a second look at the charges, it's within the remits of the law for them to do that. And I think that's exactly what is happening. We should not inject a lot of politics into these matters.
Yes, something quickly. I think I say that those who are opposing the filing of nolle prosequi, especially if it is on the basis that there's no sufficient evidence. I just will ask them to read the case of Doji Saba. I mean, this is a case where this gentleman's brother confessed to the police that he killed some assailants on his farm. And the gentleman actually brought his brother to the police station to avoid the family being, of course, lynched or disturbed. Then he was also added to him, and they were in remand for 8 years, convicted for murder, and sentenced to suffer death. He was lucky to have his conviction overturned at the Court of Appeal. So almost 10 years, 7 months. In fact, he was on death row for 2 years, 7 months. Then eventually, the Court of Appeal overturned the sentence and the conviction, and the Supreme Court ordered that he should be paid a compensation of 34,000 Ghana cedis. You and I, our tax. All because he had insisted from the day he was arrested to the day he was convicted in the High Court that he was never involved. And yet, nobody listened to him from the facts. In fact, the court was concerned. Just briefly, this is what the Supreme Court said regarding such convictions that have no basis. Protection of personal liberty is a fundamental human right. Therefore, one of the few instances where a person can be deprived of his personal liberty as permitted by law is in execution of a sentence or order. No system is perfect. It says that causes of wrongful conviction are generally systematic in nature. Common systematic causes of wrongful conviction are incorrect, informal or complainant evidence, incorrect or false eyewitness identification, flawed forensic evidence, police or prosecution misconduct, overzealousness to secure a conviction, incompetent, that word, or faulty legal representation, wrong direction of jury, and tainting of jury, for example, by corruption or even by media influence. This is by Sophia Dinra, Mrs. JSC. Okay, so all these things come together. And when an Attorney General has observed that in view of these guidelines, it is appropriate at a particular time to withdraw the suit. And eventually they were rearrested. Right. But the point, just to conclude, is that it is only in this country, generally, that a police will take an accused person into court. My Lord, remind him, investigations are ongoing. We have not finished with investigation. So why should you insist that he should still be remanded? Especially where, just last week, Justice Doty was even complaining at the forum.
The case of the Chinese woman and others, the court said clearly that you cannot just come and say investigations are ongoing, and because of that he should be remanded. So they granted bail.
And in spite of the Martin Pebu case, even prior to that, we had always insisted there's nothing like non-bailable offense. Right. People are still very reluctant to ensure that accused persons are even granted bail.
Okay. Briefly, what would Kweku say about it before we deal with the final issue of the cars bought 8 days?
Well, the lawyers have provided us with the perspectives. It's a non-issue.
It's a non-issue. Yeah. Okay, so we take our final break. We'll be right back to deal with a government that has 8 days to exit after an embarrassing defeat, importing vehicles for the incoming presidency, president and the vice president or the first lady and so on, allegedly without any consultation with those who would be using those cars. We'll be right back.